Federal workers now have until tomorrow to decide whether to take a buyout after a federal judge extended their deadline. This as both sides will be in court to argue.
In the modern era of warfare, the most devastating battles are not fought with ballistics or cyber attacks, but with paper. The most effective soldiers are not uniformed infantrymen, but litigators in bespoke suits. And the most critical terrain is not a border region, but a federal district courtroom. We are currently witnessing the deployment of a strategy so comprehensive and so aggressive that it threatens to redefine the separation of powers in the United States. As the second term of Donald Trump begins, a new front line has opened. It is not in the streets, but in the docket. We are watching a coordinated, premeditated legal bombardment designed to freeze the executive branch in its tracks before a single policy can be implemented. This is the new resistance. According to recent analysis from Fox News, a massive coalition of advocacy groups, blue state attorneys general, and legal organizations has prepared an onslaught of lawsuits specifically targeting President Trump's executive orders. This is not sporadic opposition, it is systemic lawfare. The objective is simple: paralysis. By challenging every signature, every directive, and every personnel change, this resistance aims to turn the judiciary into a firewall against the executive agenda. But this strategy raises profound questions about the nature of democracy itself. If a president is elected with a mandate, but is legally barred from governing by unelected judges, who is truly in charge? Welcome to One Day Ago and Now. Today, we are going deep. We are moving beyond the partisan shouting matches to analyze the mechanics of this legal blockade, the constitutional crisis it invites, and the national security implications of a White House under siege by its own court system. Is this the ultimate check on tyranny, or the weaponization of the law to subvert the will of the voters? To understand the ferocity of this current legal war, we must first contextualize the history of executive power and its challengers. The concept of lawfare, the use of legal systems and principles against an enemy, such as by damaging or delegitimizing them, wasting their time and money, or winning a public relations victory, is usually applied to international conflict. However, since 2017, it has been domesticated. During Donald Trump's first term, the opposition was largely reactive. When the travel ban was announced, lawyers rushed to airports with laptops, drafting briefs on the fly. It was chaotic, emotional, and improvised. The landscape of 2025 is fundamentally different. The opposition has spent 4 years studying the architecture of the Trump agenda. They have analyzed the Project 2025 framework, they have scrutinized the rhetoric, and they have drafted thousands of pages of legal complaints with blank spaces left only for the dates and signatures. This is the industrialization of resistance. Historically, executive orders have been a tool for presidents to bypass a gridlocked Congress. From Franklin Roosevelt's internment orders to Barack Obama's DACA program, the pen has often been mightier than the legislature. But never before has an incoming administration faced a legal minefield of this density. We are seeing a shift from political opposition, which happens at the ballot box, to procedural opposition, which happens via the injunction. An injunction is a court order that stops an action. If a district judge in Hawaii or Washington state issues a nationwide injunction against an executive order, that policy is dead on arrival until the Supreme Court intervenes, a process that can take months or years. The current strategy of the new resistance focuses on 3 primary pillars: immigration, the administrative state, and environmental regulation. Each of these pillars represents a critical node of American power and security. Let us first analyze the most volatile front, immigration and border security. The Fox News report highlights that groups like the ACLU and various immigrant rights organizations have pre-filed challenges to any executive action regarding mass deportation or border closure. From a national security perspective, this is the most dangerous flashpoint. The president constitutes the commander-in-chief, with broad statutory authority to secure the homeland. However, the legal arguments being deployed rely on the Due Process Clause of the Fifth Amendment and complex Administrative Procedure Acts. The strategy here is to argue that rapid deportation violates the civil rights of those detained. If these lawsuits succeed in obtaining preliminary injunctions, the result is a security vacuum. Imagine a scenario where the president orders the National Guard to seal a sector of the border, but a federal judge issues a stay order arguing the action was arbitrary and capricious. The troops stand down. The border remains open. The policy intent is severed from the operational reality. This creates a dangerous feedback loop where criminal cartels and foreign adversaries realize that the United States executive branch cannot execute its own orders. It signals weakness not because of a lack of military capability, but because of internal legal paralysis. The second pillar of this legal onslaught targets the deep state or the administrative bureaucracy. One of the central tenets of the Trump agenda is the reclassification of federal employees, often referred to as Schedule F, to make it easier to fire career bureaucrats who oppose the president's agenda. This is the heart of the battle for control over the government. The resistance argues that the civil service must be insulated from political retribution to maintain expertise and neutrality. The administration argues that the executive branch is unitary, meaning all power flows from the president, and he cannot be undermined by his own subordinates. The lawsuits targeting these personnel changes are perhaps the most sophisticated. They utilize civil service protection laws and union contracts to tie the administration's hands. Why does this matter for you? Because the people in these positions control the flow of classified information, the regulatory state, and the implementation of foreign policy. If the president cannot remove officials he deems untrustworthy because of ongoing litigation, the risk of leaks, sabotage, and insubordination skyrockets. We saw this in the first term, where internal memos were leaked to the press to derail negotiations. This time, the battle to keep those officials in power is being fought in open court. It is a struggle for the nervous system of the American government. The third pillar is energy and the environment. The onslaught of lawsuits mentioned in our source material is heavily concentrated here. Environmental groups like the Sierra Club and Earth Justice are prepared to sue over every oil lease, every pipeline approval, and every withdrawal from international climate agreements. This is economic warfare by other means. By tying up energy projects in litigation, these groups increase the cost of doing business and create market uncertainty. Even if the administration eventually wins in the Supreme Court, the delay of 2 or 3 years can bankrupt a project. From a geopolitical standpoint, this weakens American energy dominance. If the United States cannot reliably export LNG, liquefied natural gas, to Europe because of domestic litigation, Europe remains dependent on hostile actors for energy. Thus, a lawsuit filed in a district court in Oregon has direct consequences for the security architecture of NATO and the European Union. The legal resistance is not just a domestic dispute, it is a variable in the global balance of power. Now, we must analyze the counter-strategy. The Trump legal team is not entering this fight blind. Unlike 2017, they have prepared their executive orders with severability clauses and rigorous legal justifications to withstand judicial scrutiny. They are also counting on a changed judiciary. The federal courts are now populated with hundreds of judges appointed during the first Trump term, and the Supreme Court holds a conservative supermajority. However, the resistance knows this. Their goal is not necessarily to win the final battle in the Supreme Court, but to win the war of attrition. By flooding the zone with hundreds of lawsuits, they force the Department of Justice to divert immense resources to defense. They slow down the clock. A 4-year term is only 1,460 days. If a policy is tied up in court for 1,000 of those days, the resistance has effectively won by running out the clock. This is the weaponization of procedure. It is a recognition that in the American system, the process is the punishment. Let us evaluate the impact of this lawsuit tracker phenomenon on the stability of the United States. We are looking at a potential constitutional crisis where the definition of executive power is tested to its breaking point. In a positive scenario, this legal battle serves as a robust stress test for the Constitution. The courts act as a filter, stripping away the most extreme or legally dubious impulses of the administration while allowing the core constitutional agenda to proceed. This is the system working as designed, checks and balances preventing autocracy. In a negative, and perhaps more likely scenario, we face judicial gridlock. If every major policy decision is immediately enjoined by a hostile court, the government ceases to function. We could see a situation where the president invokes emergency powers to bypass the courts, arguing that national security is at risk. This would lead to a direct confrontation between the branches of government, a Marbury versus Madison for the modern age. If the executive branch begins to ignore court orders it deems unconstitutional, the rule of law evaporates. Internationally, this internal lawfare is viewed with a mixture of confusion and opportunism. Rivals like China and Russia view the American legal system's ability to paralyze its own leader as a strategic vulnerability. They operate systems where the law is an instrument of the state, not a check on it. When they see the US president unable to build a wall or secure a trade deal because of a lawsuit, they see a superpower that is self-cannibalizing. It validates their narrative that liberal democracy is inefficient and chaotic. Furthermore, we must consider the psychological impact on the American electorate. When voters turn out in record numbers to choose a direction for the country, only to see that direction halted by legal filings, cynicism sets in. It reinforces the populist narrative that the system is rigged and that voting does not matter because the real power lies with unelected lawyers and judges. This erosion of faith in the democratic process is a long-term national security threat. A population that does not believe its voice matters is a population ripe for radicalization. The New Resistance argues that they are the last line of defense against a rogue executive. They frame their lawsuits as patriotic acts to preserve the rule of law. The administration frames these same lawsuits as sabotage by a shadow government that refuses to accept the results of an election. Both narratives are compelling to their respective bases, and the clash between them will define the next 4 years. As we look to the future, we must watch the Supreme Court. They will be the ultimate arbiters of this war. Will they continue to expand the major questions doctrine, which limits the power of federal agencies to act without specific congressional authorization? If so, this aids the resistance in dismantling the administrative state, but hampers the president in acting unilaterally. It is a double-edged sword. We must also predict the administration's response to this onslaught. We can expect aggressive venue shopping, attempting to move cases to more favorable courts. We can expect the use of the unitary executive theory to justify ignoring certain lower court rulings. And we can expect a purge of the Department of Justice to ensure that the government's own lawyers are willing to fight these battles aggressively. In conclusion, the Fox News report on the onslaught of lawsuits is not just a story about legal maneuvering. It is a story about the changing nature of power in America. We have entered an era where the election is merely the prequel to the litigation. The executive order, once a symbol of presidential command, has become a starting gun for a legal marathon. The New Resistance has evolved. They are organized, well-funded, and strategically deployed. They are betting that the gavel is stronger than the executive pen. But in doing so, they risk pushing the executive toward more extreme measures to assert authority. When the normal channels of governance are blocked by lawfare, the pressure builds until it finds another outlet. The stability of the Trump second term will not be determined by rallies or tweets, but by the outcome of these specific legal battles. The lawsuit tracker is the scoreboard of the new American Civil War. What is your perspective on this strategy? Do you believe that the courts should act as an immediate brake on presidential power, or do you believe that this lawfare undermines the democratic mandate of the election? Is this resistance, or is it obstruction? We want to hear your thoughts in the comments below. This is One Day Ago and Now. We analyze the hidden mechanics of political power to help you understand the forces shaping your world. We do not just read the headlines, we read the legal briefs that determine history. If you found this analysis insightful, please subscribe to our channel and hit the notification bell. The legal battles are just beginning, and we will be here to track every motion, every ruling, and every appeal. Stay informed, stay vigilant, and we will see you in the next video.